Good afternoon and welcome to Distinguished Visitors Lecture Series here at the Faculty of Law. I'm Deborah Parks and I'm the chair of the Distinguished Visitors Committee. And it's my pleasure to actually first just introduce you to one of my colleagues, Dr. Deloyd Guth, who is going to be in turn introducing our speaker today. So Dr. Guth is no stranger to most of you here in this room and is an expert on legal history and has taught here for many years and of course has also experience at the Supreme Court. And so he's going to be introducing our guest speaker today.
Thank you very much, Deborah. When you are called to the bar, you then are sworn as an officer of the court. And today we have the single most important officer of the single most important court in Canada with us. And he is an old friend, tried and true academic lawyer as well, comes with a wide range of practice experience, born and raised in St-Boniface, took his law degree for some reason at Moncton rather than Manitoba, and has succeeded Madame Anne Roland as Registrar of the court. So, without any further detail at all, Roger Bilodeau will address us. Sonne Lumière on the Supreme Court of Canada. Thank you very much for coming. Do you need...
Merci beaucoup. Thank you, Dr. Guth, and thank you for that generous introduction. It's good to be back in Manitoba, friendly Manitoba, as we used to have on the license plates. I have today for you a short presentation, which we often use for visiting officials at the Supreme Court, VIPs, foreign visitors who want to know how the court basically works, who does what, and the jurisdiction of the court, and its caseload. So I've taken that PowerPoint and I'll be adapting it to this audience. Some screens I'll be going a bit more quickly over because I'm assuming that you're familiar with the branches of government. I don't need to spend too much time on that today. But basically I'll focus on the jurisdiction, the history, the status of the judges, some of our stats in terms of our caseload, a little bit about the building because there's some intriguing little aspects of the building that you would be enjoyable to know, and something about the role of the registrar, which is a position at the court which I have the privilege of occupying and trying to keep, as we say, the train on time. So here we go. The starting point is to situate the court in the branches of government, which I think are quite simple or familiar for most of you here. I'll skip over this, our judicial hierarchy and who does what in terms of court levels, as you well know. And the fact that our court, the Supreme Court, is the highest court which hears appeals from all courts of appeal, the federal courts included, and has jurisdiction in all areas of law. Now, here we get to the nitty-gritty in terms of the origins of the Supreme Court. 1875 is the key date, being the date when the Act was adopted to create the court and make it our final court of appeal, to hear appeals from all of the provincial territorial courts. Now, 1875 to 1949 is a critical period because we did not have the last resort. It was not the court of last resort. We still had to go to the Privy Council in the appropriate cases. And this was, of course, abolished in 1933 for criminal cases and other cases in 1949. Now, originally, some may know, some may not know, the court had 6 judges at the start of its existence. This was increased to 7 in 1927. And came up to its current number with the abolition of the appeals to the Privy Council in 1949. So here's a a shot of the past, I suppose, the original courtroom or something close to that, when it was 6 judges, and then 7. We had color at that time, apparently, and you will notice the hats. So there you go. A little bit. The ermine still lives on, but as far as I know, I've not seen them take out those hats. And here's our current court, with the most recent appointee on the far right in the back row, Mr. Justice Wagner, formerly of the Quebec Court of Appeal, and of course on the bottom, the front row at the bottom right, our own Manitoban Marshal Rothstein. So they're all there in living color and doing what they're supposed to be doing, getting ready for cases and putting out judgments that you cannot wait to read. There we go. So the judges, of course, are all appointed by Government Council. They're chosen from superior courts or straight from the bar in some cases. Mr. Justice Binney was the last one, I think, appointed directly from the bar to the court. So it's less frequent, but it does occur and will occur likely again at some point. The only obligation, as you may know, is for there to be 3 judges from the Quebec bar or Quebec courts. And, of course, this is to maintain, I suppose, the civil law tradition, civil law background, experience, and knowledge. But by tradition and by convention, which I would dare say is probably one which will not be changed tomorrow, there is 1 from the Atlantic provinces, 2 from the Western provinces, and 3 from Ontario. And, of course, like all federally appointed judges, they hold office until the age of 75 during good behavior. So I think this here summarizes again the situation, but with a picture of our current chief who has been in office since 2000. And I believe, now I should check this and I should have known before I came here, but I believe she is the longest serving Chief Justice in the history of the court. She surpassed Chief Justice Duff, I think last year or the year before, in terms of longevity as chief, not as a judge of the court. And there you go, appointed January 7th, 2000 as chief, but had been on the court since 1989, so she has been a long-serving member of the court, and even though she is now, I think, 69 years old, has shown no intention of leaving and fully enjoys her job every living single moment. Now, in addition to being the chief, you may know or not know that she's also the chairperson of the Canadian Judicial Council, and also the committee which advises the GG on membership in the Order of Canada. So she does have a few occupations besides being the Chief Justice, and like all Chief Justices before her, she has a full load. Now, the Canadian Judicial Council, just a small parenthesis on that topic, of course, is the body which assembles all of the chief judges and associate chief judges from the various provincial courts, provincial superior courts and courts of appeal, being federally appointed. And their main mandate, as set out on the screen, is to ensure or promote uniformity, efficiency, accountability, and the quality of service in the courts across the country, the superior courts, and to review. Now, this may be the most difficult and challenging aspect of their work, but to look into and decide upon complaints by the public or by any other citizen regarding conduct of a superior court judge. And so the chief chairs that council, and that keeps her quite busy as well, with at least 1 or 2 meetings a month, and plus general meetings twice a year. So there we go for the CJC. The Supreme Court now, appeal sources. Just a refresher, but most of the cases are brought to the court by way of application for leave to appeal. The bulk of our caseload, as you will see later in the stats, does originate in that fashion. There are, of course, a few appeals as of right, 12 or 15 per year, mainly in the areas of criminal law. As you may know, in the case of some offenses, if there's a dissenting judge in the Court of Appeal, there is an automatic right of appeal to the Supreme Court. So these must be dealt with, just as in last July with the Elections Act, the Etobicoke riding election, which was straight from the Superior Court of Ontario to the Supreme Court by way of the Elections Act. And of course, references. So the latest one being the Senate reform reference, which has now landed in the court's lap, and will be dealt with in the best possible time frame. Leave to appeals. Well, there you go. About 600 applications per year. So it is a busy court in the sense that the judges are constantly either dealing with applications in terms of assessing them and deciding upon them, or they are getting ready to hear a case, an appeal, or they are working on judgments following the hearing of the appeal.
What criteria does the court use to assess the public importance, and what resources do they use to make that decision?
Good point. We have a law branch at the court. I'll get to that in a second, but we have a complement of about 19 full-time lawyers working for the court, and whose main job is to assess each and every application for leave, provide a memo with a recommendation to the judge on whether or not to grant leave. Now, public importance is, I think, is deliberately vague or general in the sense that it allows the court to have the widest possible discretion in terms of what is something of public importance at this point in time. So a case may be ripe today, but it may not be ripe, 5 years ago. So I think this gives them latitude to be able to assess based on the issues in the case, the status of the case law in the country, whether or not there are conflicting courts of appeal and decisions on that point, a whole variety of issues that come into play in terms of helping them decide what is a case of public importance. But it is, as I say, in a sense, deliberately vague, and also there are no reasons given for any decision on application for leave, again, because I believe the court does not want to be tied down with decisions in the future, which could be based on decision in the present. Ça va? Okay?
One more small
Yeah, of course.
Is there something, does the Chief Justice have final say on which cases are...
No, well, maybe she does. Now, I must say that as registrar, I don't get to sit. I have no role in the work of the 9. Whatever the 9 do as judges in their conference room or in their offices, they do without consulting me, as they should. So I'm not in that world, so to speak. What we do know is that applications for leave are assigned initially to a panel of 3 judges. And these panels rotate depending on who's there in terms of retirements and whatnot, but they can be stable for quite a while. The panel comes up with a determination, and unless there is a serious objection or contribution from the other members of the court, which there could be, then that panel's view will prevail in terms of granting leave. But I think they do discuss all of them as a court at their monthly conference, and they go over every one as a full court. So there is an initial take by the panel of 3, but then the full court does make, a seal. It gives its seal of approval, so to speak, at the monthly conference.
I know that leave to appeal used to be heard in person. It wouldn't be always written.
Mm-hmm.
Do you know if the statistics have changed on how many leaves are granted now that it's written as opposed to before it used to be heard in person?
I'll have to get our staff to research that point. Sorry. No, I don't, because it's been a while since the applications have been only in writing, and I'm not sure if we have kept those statistics, but I'm sure we could put something together. Unfortunately, I don't have the answer for you, but I would hazard a guess that they probably grant a bit less today than in the past. And I say that because I think there is a strong tendency on the part of the court to really control its agenda and its docket, and to make sure that cases that are coming to it are ready or deserve or should be there at that point in time. But again, that's only my own speculation. So the status of leaves is as shown here. The right of appeal, again, I spoke to this already, so references. Now this is a small diagram I invented just to show the flow of cases, but basically there were 3 doors to the court in terms of how you get in. A decision is made on whether or not to grant leave. If yes, there is a hearing, and once there's a hearing, there's either oral judgment or it's reserved, as is most often the case, and then a formal judgment is issued after the hearing. Now, here are the caseload numbers in terms of the court sits 3 sessions per year by law. Here's about 75 to 80 cases a year. And the court, the chief, I think, really aims to have all 9 judges sit on every case. That is the aim, and I think it is achieved in about 80% at least of the cases. Now, some matters will fall to a panel of 7. I have not yet seen a panel of 5, although it could legally occur because the Act provides for that. And all hearings are public, except for the occasional odd cases where there is a publication ban or a national security dimension which applies and prevents publication. Since '85, we have, a bit like this room, improved audio, video equipment, which allows for, and this is something which the chief is very happy about, the live webcast, so that you can be here in Winnipeg listening to a hearing, live, indirect, from the courtroom in Ottawa. But also it allows for video conferencing so that a lawyer in Vancouver can be making arguments to the court by video conference in a case. Parties have 60 minutes each, appellants 60 minutes, respondents 60 minutes, interveners, if they're lucky, 5 or 10. They have to really hone into what they have to say. And all hearings, as I say, are broadcast. Judgments are rendered orally, very seldom. Most often there is a reserve with reasons prepared. All decisions, as you have seen, are published simultaneously in English and French. So this requires substantial amount of work in-house to make sure that both versions are ready, able and ready to be published. As you can imagine, terminology, vocabulary, the choice of words has to be precise and complete and thorough so that both versions are equally authoritative and provide the court's decision. Here are the stats, basically from 2012. Which reflect, I think, what I've said earlier pretty well. So that it's a pretty stable caseload. The court hears basically about 1 case per day. It sits about 2 weeks a month during each session. So it does not sit in July, August, and September, and occasionally sits in June. But given that it sits 2 weeks a month, given that it hears 1 case a day, there are very seldom exceptions to that. There's a limited number of cases it can hear per year. Now this one, I'm not sure how clear it is for you, but we're trying to show here how many cases have been where the appeal has been allowed or dismissed. And it's sort of a statistical chart showing the percentage of cases where the appeal was allowed or dismissed. The last 4 years seems to be quite stable or quite close in range in terms of about 36 to 40% allowed and the 35%. Now that doesn't make too much sense to me, but there you go. Oh, yes, thank you, as opposed to percentage. See? There we go. Average times for wait for the each step in the process. We have 4 months approximately from filing an appeal, filing the application, to a decision on the application. And we really make every effort to stick to that target so that parties are not left hanging forever in terms of whether or not the case will be heard. And then from leave to the hearing date, approximately 8 to 9 months. And the target for a decision, like most courts, is about 6 months. Now, given that Some cases are more complex and difficult than others. Of course, that is an average. We know that some cases already are pending since about a year, so you have to keep that in mind. Now, the court members do have some what I call extrajudicial responsibilities, especially in regard to maintaining links with other courts, other Supreme Courts. And I think this is something which is not as known or understood by the public or by the bar, but I think it makes perfect sense, and it is a valuable thing, because as a Supreme Court of Canada, I think it's essential for this Supreme Court to maintain connections, links with the Supreme Courts of the US, India, Australia, New Zealand, Conseil Constitutionnel de France, Germany's Constitutional Court. And so every so often there is a visit by members of these courts to our court and vice versa, for them to exchange during a couple of days on topics of mutual interest, human rights, labor law, access to justice, privacy issues, right to information. So they have a variety of panels that they set up themselves with a judge from each court presenting, and for there to be a discussion with other members of the court. So these are maintained on a regular basis, depending, of course, on timing and schedules. Judges, of course, as you know, often attend judicial events in this country, give a speech, give a conference. So they're in big demand. They're working hard inside the court, but also outside the court in terms of delivering various presentations. Here's a view that is from behind the court, but gives you a sense of its majestic situation in terms of the hill. And here's a look at the past. The court building, 1875. The court first sat in the railway committee room in the Parliament buildings, so it was not quite as elaborate as today. 1882, and here's something I found out just this week. The building that was renovated or converted to the court in 1882 was apparently a former stable in Ottawa, close to Parliament, which was converted into the Supreme Court and housed the court and the art gallery on the first floor, and the court being on the second floor. So this was the Supreme Court until 1946, with our current building designed by a famous Montreal architect, Ernest Cormier, and the Queen who laid the cornerstone, 1939. And because of the war, because of the usage of the building for some war purposes, it was not occupied by the court until January 1946. But it is a special building, and one which we can all be proud of as Canadians. And I do invite each and every one of you, if you're in Ottawa, come on for a visit, and I'll be happy to take you around, show you the main rooms and some of the secret rooms in the back. Here's our courtroom, formerly, before the audiovisual improvements were made. And here's today's version with all of the bells and whistles. We have screens on each side to give a better view to the public. The audio is better, lighting is better, and of course, simultaneous translation is offered for all participants, counsel, judges, and members of the public, as needed. And here's where the big decisions are made. So the judges sit around this table after each hearing and deliberate and discuss. They come to some, I guess, preliminary conclusions as to where the decision is going. But this is their work table. Another view of the same room. And we also keep, in the back there, our rare book collection. So Professor Goot has a special interest in that place. These books, some of them go back to the 1600s, France and England, law books, which I'm sure are not frequently found in other rooms these days. Now, the office of the Registrar, to complete the picture, think in the abstract of the court as being 9 judges, and they are the court. And what they do as members of the court is their business. The office of the Registrar is a separate entity, so to speak, an administrative body set up to support the court so that the judges of the court have the equipment, the personnel, and the tools that they need to do their work. And so the Office of the Registrar is headed by the Registrar, along with the Deputy Registrar, and basically we aim to ensure the proper administration of Canada's Final Court of Appeal. We have about 200 staff altogether, which I'll get to in a second. So the chief, of course, heads the operation, and I work closely with her, or with him, if it was a him, and ensure that the registrar and the office of the registrar are doing what has to be done so that the chief and the court are supported in their work in terms of administrative support, equipment, tools, and the like. Now, the executive legal officer on the left-hand side of the screen, or right-hand side, sorry, is a newer role, at least about 20 years or so, 25. Justice McPherson of the Ontario Court of Appeal was the first one, I believe. Bob Sharp, Eugene Meehan, quite a few luminaries in the legal world. And so, in fact, Justice Dixon, Chief Justice Dixon, I think, started the whole thing and wanted to ensure there was a proper officer of the court who would be of assistance to the court. And his or her main role, in my view, is to be the spokesperson on behalf of the court in regard to the cases, the substantial issues in the cases, so that the media have a better understanding and are able to assimilate and to understand what the judgments are about. So that person is the mouthpiece of the court in terms of explaining judgments and also in terms of answering questions by the press or by the public about what a case means. His other role, because currently it's a him, Mr. Owen Rees, is to support the chief in all of her management of the court duties, assigning cases, judges to cases, coordinating to some extent judgment production, making sure that the court's work is moving along. And also the executive legal officer assists the chief in her work at the Canadian Judicial Council. Typically, it's a lawyer from practice, a professor, a academic, somebody in the legal world with about 10 years standing at the bar or somewhere, who has a good understanding of the court, of the law, and who is brought in for 2 or 3 years. It's a term appointment, and it provides a great assistance to the chief and the court to deliver on their duties. The registrar and deputy registrar oversee the operations of the court. The key one being the court operations sector, which I'll briefly explain. Communication services provide any manner of information to the public. So the distinction with the executive legal officer is the ELO provides information in regard to cases. So what does the reference mean? What does the decision in R versus XYZ have in terms of impact on the criminal law? The communications sector will provide general information to the public about the court's work, statistics, who the judges are, where they're from. So that type of information, to teachers, schools, any member of the public visiting the court. The court operations sector, we have the registry, per se, the law branch, the library, and the reports branch. And so briefly, the law branch, as I explained earlier, is a complement of lawyers who assist the court in assessing applications for leave, but also have a good hand to play in finalizing judgments in terms of editing, proofreading, and some research on very special points that the judges may want to have researched. The reports branch puts out our Supreme Court reports, does all the editing, the proofreading, the jury linguistic services, because we need to ensure that the French-English versions are both exact. And the registry branch, of course, ensures that anything coming into the court is properly handled, assigned, stored, sent to the judges, and kept track of. And of course, our library has a 300,000 book collection, one of the most, I think, thorough in the country, and we need to make sure that it's up to par. So there you go. The library has an extensive collection, both in common law, civil law, electronic collection, paper collection. Judicial support is a sector assigned to supporting the judges' chambers in terms of Each judge has an assistant, has an attendant, and 3 law clerks. So this is a way for us to keep the chambers going in terms of the staff they need to make their chambers work properly. The corporate services is, well, what our 2 friends are doing here, the IT, the electronic support, the business planning, resource planning, finance, accommodation, HR, all the tools which an organization needs to maintain its proper functions. And communications, as I mentioned, is dealing with the public, ensuring that visitors, we get about 40 to 45,000 visitors per year in the building. So we have a tour guide program, we have a correspondence program because many people write in, they want to know various pieces of information about the court. So we deal with those questions, and also for internal staff communications within the court. So basically the role of the registrar, as I summarize it to some other audiences, is to be the administrative head of the office of the registrar. There are quasi-judicial powers under the Supreme Court Act, especially regarding procedural matters, extensions of time, dealing with cost, taxation on each file. So there is that role. Some outreach to various organizations, the bar, internationally, nationally, and also for the administration of allowances to judges under the Judges Act. So the Commissioner of Federal Judicial Affairs oversees various allowances to all federally appointed judges, about 1,000 or so. I do the same thing, but only for the 9 judges of the court. So on some days I have to say yes to something and no to something else. It makes for an interesting day. So outreach, well, we have official delegations, we have Francophonie, we have Commonwealth, we have the CBA. The court does maintain some active participation with each of these outfits, and I assist the court in doing so to ensure that the court maintains proper linkages and networks with various Supreme Courts, Cour de Cassation, and Supreme Courts in other countries, as well as bar associations. So I invite you, when you have a spare moment, after being in class all day, if you want to check out the Supreme Court website, it has a lot of the information I gave today, but in a different format, and also the schedule of hearings and any question that you may have about the court's history or the history of all the judges who have ever sat on the court from the beginning of time. Here's a special view that I prefer, I enjoy. I think the architect had a great idea when he drew up the building. This is one of the center windows in the Grand Hall. And it to me conveys the symbol of access to justice, of transparency, of having light brought into the building, and ensuring that justice is not only done, but seen to be done. And here we go. The branches of government from a picture point of view, so Parliament, the court, both are shown in this picture, and gives you, again, a rear view of the building. And there are some moments to enjoy life, and here's our friend Mr. Rothstein watching Madame Deschamps blow her birthday cake. So it just goes to show they are human, and they do enjoy the company of each other, and they do have a bit of fun every so often. And we have a mascot. So you now know that the Supreme Court has a mascot. His name is Amicus. I think it's quite appropriate. And on Canada Day, Amicus comes out to meet the public, and the Chief and Mr. McCardle were happy enough to pose with her last couple of years ago. So there is life in the court. It's not just about judgments, although that is the biggest piece of work. Thank you for your attention. Any questions that you may have, I'll try to answer.
Well, thank you for that. I think it's great that some students already asked questions in the middle. I have the mic, so I want to get the questions recorded for the video as well.
Of course, I'm not asking for the progress of any particular case. I realize that would be inappropriate, but I was just wondering, in general, if you could explain how the 6-month rule works. I noticed there are some cases that Madame Justice Deschamps sat on, that haven't been ruled on yet. I checked the website today, and today was, I think, the 6 months after she retired. Hypothetically speaking, if a judge had already written a decision and or voted on it, would that judge's work count even if the judgment is handed down after the 6 months have expired?
Yes, we are. I'll seize the question to bring to your attention that we are in the middle of 5 consecutive years of changes on the court. Going back to Justice Binney and Charon, who left. This year, Justice Deschamps, or last year. In November of this year, Justice Fish will have reached the age of 75. In November of 2014, Justice Lebel will be 75. And in December of 2015, Justice Rothstein will be 75. So we're looking at quite a bit of change. And what happens is, for every departing judge, the Supreme Court Act provides that there's a 6-month window for them to stay on if they so desire, or if they feel it's necessary, for them to pursue and finish their judgments that they are writing or working on. So in the case of Madame Deschamps, this was done, and she stayed on for 6 months, not as a judge, but as former judge who is writing judgments. And what happens is that judgments that a retiring judge is writing on need to be put out before the end of the 6-month period. So that in her case, her 6 months expired on February 5th, in fact this week. And so that any judgment that she was writing on had to be issued on February 5th or before. If not, then the court was faced with having to order a rehearing in a case where a judgment would not be put out. So it is a serious matter, but one which they deal with and know it's coming. Now the other option, or not the other option, but the other angle to this is that if Madame Deschamps is on a panel but not writing, then the court can issue a judgment beyond the 6 month or beyond her departure with an asterisk or a footnote indicating that Madame Deschamps did not participate in the judgment. So that's how we deal, or that's how the court deals with cases where it seldom happens, where the judge has left and there is a judgment coming out.
And just to follow up on that, so that means that sometimes this is why sometimes, and I know this has come up in some of my classes, where you have a decision where 9 judges actually were sitting, but the decision is only of 8, for example, and you can sometimes have a 4-4 or something, which isn't desirable in those situations, or you can end up having 6 or something, which has happened in some cases, right? Okay. Another question?
They're very mindful of this, and they try to avoid those situations.
Do most of the justices use laptops when they hear a case?
Well, that's in fact something we're working on now, and they are working on. But I can say this, in the courtroom, and I'm not sure if it showed it, but every judge has a laptop in front of him or her. And some do use it quite a bit, mainly to consult the documents in the case, but also, I'm not sure if the picture shows it, but on the right-hand side, left-hand side of the courtroom, we have all the clerks, not all the clerks, but the 9 clerks. Each judge has 3 clerks, and so they will be sitting on this table here, so that for each hearing, there's 1 clerk for each judge. And what often happens, I'm told, is that some judges, more than others, will be chatting or typing away with their clerk, either getting questions or observations or suggestions on the hearing, or did you think about this, or do you want to ask about this? So there's a great deal of, this is done through the laptop in front of each judge, and of course each clerk has a laptop as well. So that's one piece of innovation. The other one, which I'm happy to announce, as of October last, and at the urging of the Chief Justice and others, but Professor Good will appreciate this from his past days with her, because of her work at the Governor General, where they now have all the applications for the Order of Canada on iPad. She figured, well, can we get all the applications for leave on an iPad? And lo and behold, we do. So that as of October, they now carry an iPad, a dedicated iPad, which is not connected to internet for security purposes, but is downloaded with all of the leave to applications for leave. And so they can deal with them more easily if they're at home or traveling. So we're slowly working towards making much better use of electronic resources. In fact, we're in the middle of a business process transformation initiative which aims to reduce paper. We have no illusions that there's going to be some paper around at some point, but less paper is where we want to go. So laptops are used. They have a laptop at home. They have one in the office, one in the conference room. So the judges are perfectly connected at all times if they so desire.
Maybe it's a bit good to ask this question. Sorry, Gerald, because it's a bit of a follow-up. I had the privilege of speaking to the members of the Supreme Court last month, and one of them was complaining to me that colleagues are resistant to change, and then the conversation went on to just generally how resistant to change human beings can be. So my question is, as these innovations are coming, and you talked about them as sort of business process management, and you identified your role in that aspect of things, how much resistance to change are you encountering at the level of the justices, but also at the level of counsel who are bringing matters before the court? And how will you manage or help ensure that things still go along that direction? Thank you.
Thank you. Well, for sure, human nature being the way it is, there is always some resistance. But for the most part, we've seen a welcoming approach on the part of many judges, at least, to using technology. But of course, some use it more than others, and some are watching and looking and wondering, well, is this going to really work? And if yes, I'll jump on. If not, I'll continue with what I'm doing. So I think it's very much, we have to keep in mind, there are 9 chambers, and they are 9 separate chambers in many ways. It's almost a collection of islands, that form the court. So they work together, but they also work separately. Now, in terms of putting change or operating change in terms of technology and how we do business, I would say that we're making good progress and that there is at least an interest on the part of most judges, and some more than others. For one, the bar is very much on board as far as we can tell, because we have regular meetings with the what we call the agents, who are acting often for the parties, but also with the CBA, who has a liaison committee with the court. And so we don't see much resistance at all on the part of the bar. And in terms of our business transformation initiative, we have one member of the court who is a member of the steering committee, so that there is a tie-in there. So I think it's a gradual process, and personally, I don't foresee there'll be too many obstacles, but we hope that things will move ahead.
Hi, I just had a question. You mentioned that hearings, there's simultaneous translation at the hearing, the judgments themselves are translated. Are materials like FACTA, motion records, are those translated at all? And are draft decisions or draft dissents or draft concurring judgments, are those translated as they circulate amongst those islands?
As far as I know, the documents in a case are not translated. They are dealt with in the language they are presented, and I don't think there's any issue on that front at all. In terms of decisions, what happens is, in general terms, when a draft decision is ready, it is immediately sent to our translation people for a first draft in the other language, comes back to us, and this is when our team of editors, jurilinguists, revisers, proofreaders, lawyers get in the saddle and ensure that the work as it progresses both at the judge's level and in the other language is kept current. There is a small joke within the court that nothing leaves the court without having been checked 4, 5, or 6 times. So we're a little bit, paranoia about that. But it is very much revised and checked on numerous occasions. So there is a gradual process for ensuring that any decision, of course, is prepared in the other language as closely as possible as the one in the original version.
But if I can add, the contents of the court case file remain in the language of the
Yes.
of the pleading.
Yes, of course.
So I should confess that when I was hired by Chief Justice Brian Dixon in 1987 to sort things out, there were 3 levels below the library that were just jammed full of court case files and the private papers of preceding judges. And they were all sort of dropped off behind chicken wire, and it was an archival nightmare, which one of the things he wanted me to sort out. But the switch to electronic does create very serious archival issues as well. I mean, how much is stored and for how long? When I left the court, we had a contract with the National Archives, which I believe is still in effect, for deposit. But what's going to happen now in the paperless court?
Well, just a small second here. If you look at the library title, we've changed it. The library is no longer just a library. It is the information management branch of the court. And so they have been given responsibility to engineer an approach and policies and guidelines to which records we keep. And of course, there are the case records, there are administrative records, and there are personal records. So each of these categories are kept distinct and separate. As I speak, we are putting in place, or have put in place, guidelines on the management and preservation of electronic and paper records. So we are fortunate to have a very on-the-ball librarian, Mrs. Fox, who's spearheading this and working with the judges closely. We also have the oral history program, so that each departing judge is interviewed, and there's a record prepared of each judge's time at the court and their recollection of what happened. And their papers, of course, are sent to the archives and managed and stored in a proper manner. So I'm confident that we're doing what has to be done, but there's always room for improvement, and making sure that in this day and age that electronic papers or records don't get waylaid. Stay tuned. But we are very much on top of the issue.
Okay, well, I think that's a nice way to finish off, and I just want to, on behalf of the faculty and students here at Robson Hall, give you one of our coveted Robson Hall coffee mugs as just a small token of our thanks for you coming and speaking to us today. Thank you.
So kind. Thank you so much. My pleasure.